Hello and welcome to the Business and AI Forum. We have a day of programming focused on showcasing how business and business functions are being impacted by AI technologies. Without a firm understanding of how governance, organizational capabilities, risk management, investments, ROI, and adoption efforts are being implemented, organizations cannot readily make use of AI as a competitive advantage. My name is Joaquin Melara, and I am the founder of the Swarm community, as well as the host of the AI Digest podcast. And Swarm is a community of practice focused on solving ESG related problems with open source AI technologies. With us today, we are going to have the lovely Nancy Steidl. You might have noticed how much the space of intellectual property has been under scrutiny in regards to AI technology. You may be able to relate with the level of obfuscation and lack of knowledge around this area. But thankfully, we have Nancy here to give us a great overview on what it is, why it's important, and how it impacts us all. So, Nancy, the IP specialist expert, please take it away.
Thank you very much for having me on the show today. I'm very excited to be with other top experts today. We're talking all about the age of AI with our specialties, and my specialty is intellectual property law in the age of AI. Myself, I'm an international business consultant and intellectual property law specialist with over 25 years of experience. I've completed 3 masters, all to do something with AI and IP involved. You can find out a little bit more about me on my LinkedIn profile as well. So I just like to start off with a brief overview of AI technology, the importance of intellectual property in the AI age, and the overview what we will be covering in the presentation. So IP comes in lots of different sort of levels. There's trademarks, there's copyrights, there's patents. Artificial intelligence is like the brains behind the technology we use every day, from personalized recommendations on streaming platforms to voice assistants helping us navigate those smartphones. So it's not just about machines following commands anymore. AI can generate new ideas and it can solve those very difficult problems and even create art. So now imagine AI as a creator coming up with new inventions and innovations. That's where IP comes into. So intellectual property is like a shield that protects these ideas and helps people and companies, own and benefit from their creations. So without intellectual property, anyone could take credit for somebody else's work and innovation could grind to a halt. So today, we are going to dive into how artificial intelligence and intellectual property work together in our modern world and explore the challenges and opportunities that they bring. So the historical content and IP and law of their evolution, we're going to discuss the challenges and opportunities presented by AI technology and emerging trends. So here I've just put a really nice little timeline of key events in IP, which is very interesting. As you can see, in 1972, it started off with one certain case, and it has risen up to 2017 and has gone beyond that. So the rules around owning and protecting ideas have evolved over many times, shaped by technology advancements and social changes. So from early days of patents and copyrights to the digital area of intellectual property, our legal framework has continuously adapted to new challenges and opportunities. Now, with AI in the mix, we are facing a new frontier. So AI brings a really unique challenge to the sector of IP, from questions of ownership and inventorship to protections of AI-generated work. So we need to really update our laws and to keep up with these changes and ensure that everyone gets fair credit to their contribution of AI in the age of AI. At the moment, with the IP laws, animals and robots actually cannot own their own IP. So that's going to be something we definitely need to change. Here we have the emerging issues of intellectual property. We've got the digital and virtual goods, the artificial intelligence and IP creations, the global IP enforcements, the Privacy Data Protection Act and the IP, and other sustainability and IP issues as well. So intellectual property encapsulates a broad spectrum of rights that protect different AI creations. So for example, patents, they provide exclusive rights to inventors for new and innovative AI algorithms and technologies. We also have copyrights which cover creative works generated by AI, such as artwork, music, and literature. We have trademarks which help companies protect their brands and distinguish their AI products and services from their competitors. Trade secrets safeguard valuable AI-related information, such as algorithms and data sets. Understanding these different types of IP is very crucial for AI developers, businesses, and creators to protect and monetize their innovations effectively. So as I mentioned, here is the list of different intellectual property that is relevant to AI. So we've patents, copyrights, trademarks, and trade secrets. So let's talk about ownership and the consideration of businesses and case studies as well. So one of the most pressing questions, I would say, is in the age of AI is who owns the things that AI creates? Whether it's a piece of music composed by an AI algorithm or a new business process optimizing by machine learning determines ownership rights is really essential for fostering innovation and creativity. However, AI-generated works blur the lines of traditional authorization, authorship, inventorship, and this raises really complex legal and ethical concerns. As AI continues to advance, stakeholders must grapple with the questions of attribution, compensation, and responsibility to ensure fair and equitable outcomes for all involved parties. So what's the importance? As I mentioned, we have to discuss the strategies of collaboration and the legal considerations. As you can see here in my PowerPoint, there's about 4 or 5 different points that we really have to look at. Innovation often thrives in collective environments where individuals and organizations, they share knowledge, they share their resources, they share their expertise. And in the field of AI, collaboration is necessity and essential for tackling complex challenges and driving that technology forward. However, effective collaboration in AI innovation requires really careful consideration of intellectual property rights, including ownership, licensing, data sharing, and agreements. By fostering these collective ecosystems that balance innovation with IP protection, businesses and researchers can accelerate AI advancements while maximizing the value of their intellectual property assets. So we are defining the inventorship in the context of AI, identifying human inventors in the AI, and the legal aspects of it as well. So we need to look at traditionally that inventors have been human beings who conceived and reduced to the practice of new and useful inventions. As mentioned before, animals and robots cannot own the IP right now with the laws that we have. However, the rise of AI introduces new complex legal actions to inventorship. As AI systems become increasingly capable of generating inventive solutions, questions will arise regarding who should be credited as the inventor of this AI-generated inventions. So balancing the contribution of humans and machines in the innovative process is really important for ensuring a fair recognition and a reward for all parties involved. So we need to proactively have an IP protection. We need to craft robust IP policies and agreements, and we need to leverage licensing and enforce mechanisms in the IP. So here's some great case studies that I've come up with, which was Google DeepMind. So DeepMind was acquired by Google in 2014, and it's known for its advancement in deep learning and reinforces learning algorithms. DeepMind have strategically managed its intellectual property by filing those patents for groundbreaking AI technologies, such as AlphaGo, which achieved superhuman performance in the game of Go. By protecting its innovations through patents, DeepMind retains control over its technology and can license these to partners. A couple other examples is Amazon. So Amazon is a pioneer in using AI and machine learning to enhance customer experiences and optimize business operations. Through Amazon Web Services, Amazon offers AI-driven services such as Amazon Recognition for image and video analyze, and Amazon Lex for conversational interfaces. Amazon strategically manages its intellectual property by securing patents for all its IA technologies, allowing the company to protect its innovations and monetize them through AWS services. Finally, third case, Microsoft. Microsoft has made significant investment in AI research and development, leading to the creation of AI-powered products and services amongst its ecosystem. From virtual assistants like Cortana to AI productivity tools like Microsoft 365, Microsoft has managed its intellectual property through patents and licensing agreements. And by protecting its AI innovations, Microsoft fosters innovation within its organization and collaborates with its partners to bring AI-driven solutions to the market. So these real-life cases provide valuable insight in how businesses and organizations navigate the intersection of AI and intellectual property. And by examining these examples of successful IP management strategies in AI-driven industries, we can definitely learn from practical experiences and identify best practices for addressing common challenges and opportunities. From these big corporations also to innovative startups, these case studies offer inspiration and guidance for navigating the complexities of AI innovation and IP protection in today's digital economy. So, what are the future trends and how can we anticipate developments in AI technology and IP laws? What are the key considerations? So, looking ahead, the future of AI and intellectual property is really full of exciting possibilities and potential challenges. As AI technology continues to advance at a very rapid speed, stakeholders must anticipate emerging trends and consider the implications for IP law and policy. From AI-generated content to ethical implementations of these automatic systems, navigating the evolving landscape of AI and IP requires foresight, and it also requires collaboration amongst companies, stakeholders, and society in general. By staying informed and proactive yourselves, you can shape the future where AI innovation is harnessed responsibly and ethically for the benefit of the whole society. So I do welcome any questions if anybody is on listening. If you have any questions or thoughts about AI or IP, let's open the floor and discuss it.
Yeah, if you have any questions, feel free to add the comments below here in the presentation. I want your thoughts on navigating this turbulent period where we are in the internet and we are sharing our information freely, publicly through our websites. But there are platforms such as Google and other search engine platforms that can readily scan and access our information without our immediate consent. There are also people that can appropriate our knowledge through our websites without our consent. Is there a means to regulate this behavior so we are not in particularly just a vulnerable position? And if we find that somebody has misappropriated our information outside of the use of what we deem to be correct, how do we find retribution?
Well, that's a really big question. And it's like being a sea of ocean with fish. I mean, the internet is a really big place. And when you are putting out content, it's very, very hard to find that content that's swimming around. And sometimes it does land in your space, and there are things that you can do, like copyright infringement. If you are finding that your content is on Facebook and somebody has stolen the content and used it somewhere else, you can report it to Facebook. But as they are a big corporation, they have probably a lot of copyright infringements. I do believe it's a bit like a speeding ticket. So you might not get caught right away, but you will get caught by using other people's intellectual property. It's so hard right now. That's a really tough question to answer because we don't have enough regulation. The law for IP in the AI world is so behind because it doesn't regulate the internet. And even IP now, when you are putting things, you are maybe using chat gbt and you are pulling other people's words out and using them as your own. Well, you have these authors who are already suing chat gbt for using their content. But it's a really tricky question because right now we just don't have enough laws, and we are moving so fast in the world of technology in the digital era, that we need to secure some more laws for the IP side of it.
Can we borrow examples from other places where IP is a area of contest, like publishing or music or movies? I know
Absolutely.
I know for movies, you have people. Well, you used to have people sell you these bootleg copies of movies that they kind of recorded on their own in laundromats and shops and in local markets. That's infringing on private property. Um, how is this a way to, how are they handled, and how is this a way to view the way that we're handling misappropriation of intellectual property in this day and age?
Well, I mean, you come really down to taking these people to court. That's the only way. The more people that do take these people to court and make a bigger stink about it, then there's more, there's a fear like, okay, well, I won't steal somebody's IP because it's going to go down this route. And even with technology, music is made by robots. And the robot could be pulling music from, I don't know, Taylor Swift, or, all these other people that the music is out there already. And you might not even know that, and you're creating a song. And, there are a lot of cases, it was, Ed Sheeran had a very big case where somebody thought, had used his music. Katy Perry had a similar case. But again, with robotic music or with AI music being created, where is this, AI pulling this music tune from? And that could be another case as well.
How should companies navigate this very sensitive period where everybody says you shouldn't use data that doesn't belong to you, or you should use publicly accessible, publicly available, commercial free, licensed knowledge assets? How do we navigate this period when we need access to high quality information to create relevant systems?
Well, it's really important to do an IP strategy for your company. And that's the first, sort of the framework. But also, I think being empathetic and considerate and understanding where you're getting that content from. And if you are using content that is already created by other people, you should approach that person and using it. And secondly, also give credit to that person when you're using their work as well. In most cases, you will have to purchase a license in order to use it. A lot of people go on the internet and they just pull a photo from Google and they think that they can use it, and that's absolutely incorrect. You need to have authorization from these people to use it. It's only fair because the creative person that created it should have, recognition for doing that, and also possibly be paid for the work that they put into it.
What are the punishments, or what are the deterrents of bad actors, naughty organizations that keep taking things that don't belong to them?
They go to the IP infringement jail. No. But basically, there's lots of fines involved. I mean, it comes to a point. I mean, with trademarking, for example, if somebody trademarks, if I have a client and they've been somebody else is using their logo, which they've already trademarked, we would send them a cease and desist letter. At that point, hopefully they will get the hint to drop that name and no longer carry on. But you can go into very hefty fines. There's also the problem of, I'm giving the example of IP of trademark, but you'd have to rip down your trademark. You'd have to redesign the trademark and come up with a new name, which is very costly. You'd have to rip down everything that you find on the internet that could be associated with the trademark holder.
And what is composed of this intellectual property strategy? How would small, medium size, even entrepreneurs, how do solopreneurs work to navigate that with the resource constraints that they have?
Yes. Well, it's better to have the funds to get your trademark or your patent in place because, like I said, it's quite hefty before that. So when you do start a business, you should always trademark the name, or even if you've got a patent, you should go ahead and do the patent. Now, I know the process can take long and it can be quite hefty of a fee to get involved with IP, but it's better to do that. So the IP strategy is to maintain that first of all, and then you can employ somebody to track your IP to see if other people aren't using it. It's a very big responsibility, IP, when you decide to set up a company. It's not like, well, I'll go get a trademark and then that's it. You got to man the trademark. You got to make sure that other people aren't stepping on your IP. It's the same with a patent, same with copyright. So any business that you set up, trademarks are good for 10 years. Copyright is good up till life plus 70 years. And so you're going to really have to monitor what's going on with your trademark. And that includes a strategy. So understanding every year what you're doing with these trademarks or with these patents or anything with your IP. But an IP is a really, really big asset to have and a valuable asset in your company to obtain.
Yeah, thank you for bringing that to the point. I mean, you have your physical assets, you build a business, but that is true when you create a trademark, when you create a intellectual property, when you create a brand, that does become an intangible asset that is a bargaining chip if you are going to sell the business, if you're going to expand it, if any other situation like that. So at some point, if you have a continuous profitable business, I guess it is seeding an investment of sorts, right?
Absolutely. I mean, in some cases, some businesses also hold their IP in separate bank account or business accounts. So
Hmm.
Nike and IKEA are similar cases where they actually hold it in a company. A trademark, you can, or even a patent, you can loan against. You can will IP assets as well. So it's really, I can't emphasize enough that it is a huge valuable asset to a business, and it's a good starting off asset because as you build a brand, people are noticing your brand. And imagine if you have to rip down your trademark after 20 years because you didn't trademark it, somebody's come along and forced you to move it. You can't even inform your audience where you've gone. And then you lose the trust of your audience as well, because they're like, well, where have you gone and why have you changed the name? So it's always good. I say to clients, don't worry about the logo, don't worry about the figurative side. But when you do go trademark, just secure the name. And as we go into this digital AI world, I step into the metaverse, and the metaverse doesn't have jurisdictions. So there's a little bit more trickier. It's chaotic over there. That's another topic at some stage. But as we are in still the reality world here we're in, IP goes by jurisdictions. So you can have some IP in the UK, but you don't have it in the US. You need to get it in the US and the UK to secure those platforms.
So depending on which market you are operating in, you have to ensure that you're in compliance with that market and you protect yourself accordingly.
Yes. Well, in one way or another, if I'm in the UK, so where I would start is the UK, my home residence. However, if you're going to be on social media platforms like Facebook or Instagram or Twitter, those are US entities. So you need to make sure that you are trademarked in the US. And then something like TikTok is actually a Chinese entity. So you need to see what jurisdiction those countries, those platforms are on in order to secure it. But obviously, the more trademarks you have in certain countries, as the business expands, if you're going to go global, you need all the countries just to secure yourself.
Who should reach out to you for more information about your services and just getting a review or an audit of what they're doing?
Absolutely. You can touch base with my business, which is thebusinessmission.com. And you can come to me directly through LinkedIn, and I'm happy to give you any information about IP in the AI world, and also right now, how you can secure your IP as well.
Great. If you guys have any questions, feel free to put them in the comments below, and Nancy will get right on that as soon as she has some time. But thank you very much, Nancy, for giving us a primer on or primer, however you want to say it. I don't know, on intellectual property rights, and there's just so much to think about when we're working in this age where anything can be misappropriated. Even if we want to consent or not consent, it's out of our hands when it reaches the public, right?
Thank you, Joaquin. I've really enjoyed this platform with you. You've done a fantastic job with this whole business and AI forum. So well done on that. And yeah, I hope this knowledge will help other people that are not sure about intellectual property or just want that advancement of intellectual property in this AI era we're in, or just where they are in today's world at the moment.
Thank you, Nancy. Ciao,
Thank
guys.
you.